A federal judge denied the request to block Chicago's security plan for the Democratic National Convention. We'll call that just DNC.
This is Dr. David Schein, and welcome to Business Law 101.
A federal judge rejected a motion by bodies outside of Unjust Laws, an LGBTQ advocacy group, to block Chicago's ordinance related to the creation of a security zone around the Democratic National Convention. The DNC will be held August 19th to the 22nd in Chicago. Due to the announcement by Joe Biden that he will no longer be a candidate, this could be one of the most raucous conventions in modern history. It's a fascinating bit of history repeating itself. The DNC was held in Chicago in the summer of 1968 during the height of the Vietnam War protests. TV news reports showed large crowds blocking the streets near the convention site. Police hit demonstrators blocking the streets with nightsticks and dragged them into waiting police vans. The chant by the protesters was, "The whole world's watching," indicating the public was watching what the Chicago police were doing to the protesters and obviously objecting to what they regarded as brutal treatment. So apparently, and with good reason, Chicago wants to avoid another black eye 56 years later. The subject lawsuit related to the group's request to protest next to the DNC. It also sought a preliminary injunction against the city ordinance that restricted a list of items, which would be things that could be brought inside the security perimeter. The list of prohibited items included laptops, sealed packages, drones, firearms, ammunition, tents, pointed objects, including knives of any kind, and any other items considered potential safety hazards. The protest group argued that the Chicago ordinance was unconstitutionally vague in violation of their 14th Amendment due process rights, and that it will have a chilling effect on their First Amendment rights. However, the judge saw it differently, ruling that the ordinance has established clearly defined minimal guidelines to govern law enforcement as required by the Constitution. The judge continued, plaintiff's argument that a protester would be punished for carrying items such as pens, first aid kits, and protest buttons is well beyond the pale of any reasonable interpretation of the ordinance. Simply put, if plaintiffs show up at the protest with pens, first aid kits, and protest buttons, they are unlikely to face punishment. And the judge actually went as far as saying, well, if there's a pair of scissors in the first aid kit, which there aren't many first aid kits, maybe the scissors get taken out, but the first aid kit itself will still be approved. The ACLU, which represented the plaintiffs in this matter, has said it will attempt to appeal the judge's ruling. This is Dr. David D. Schein for Business Law 101. If you enjoyed this episode, please subscribe on your favorite platform.